joining us now. I think I was just complimenting him. I'm like, it's kind of like the John Adams of our time. Our very good friend Andy McCarthy, who has really had some great analysis of all of this. He joins us via Skype. Andy, always such a pleasure, and of course, get Andy's book Ball of Collusion. I think it's one of the best books out there, talking about the breakdown and degradation of of our system and everything, the DOJ, all of it under the previous administration. All right, so Andy, this is. For the non-legal eagles out there, you hear people say that it's a witch hunt. You hear that it looks bad. The photos don't help. I mean, what is the real, just the very straight, no chaser, clinical take on this? What can people take home?
Dana, thanks so much. They're very serious charges. I'm, just surprised, having worked, put the law on the side for a second, having worked national security stuff for a number of years, the breadth of information we got about the classified information stuff that Trump was holding down in Mar-a-Lago. Generally speaking, the government's really tight-lipped about that stuff. So I'm surprised by that on two levels. One is just that we got the information. But the other thing is, it seems to me that he could have tried this case or charged this case. This is Jack Smith, the special counsel. He could have charged it lean and mean and just done an obstruction case if he really wanted to get to trial quickly before the election. And I think what everybody's concerned about here is what's the impact of this on the election, right? But having opened this can of worms with the Espionage Act counts and this description of the classified information, it seems to me, if I'm defending Trump, what I come back with is we need to have much more information about what's in these classified documents, and we need to show the jury more, because they have the advantage of being in what I would call the classic gray mail situation, which is the documents probably don't help Trump. They may even hurt him. But what helps him is that the government doesn't want to give him that information, doesn't want the jury to see the information because it's classified. So you at least can set up, number one, you set up an argument that if the court doesn't allow Trump to show more of the documents, his right to present a defense has been violated. And secondly, just the sheer amount of time that it takes to litigate these classified information issues pre-trial, I don't see how they can get to trial before the election.
Wow. So there's a lot of stuff that looks like it's staggered to happen right at the election. We're talking with our friend Andy McCarthy, best-selling author. You can also see him on Fox News, former Chief Assistant U.S. Attorney as well, on this Trump indictment. You mentioned the Espionage Act, and the only reason that I became familiar with the Espionage Act, not being in the legal profession as you are, is during my friend James Rosen, his
Sure.
dalliance with the Obama DOJ under Eric Holder, and I thought it was so wild that they try to go at him through that perspective. How does that apply here? I mean, isn't there some sort of like intent to distribute that's attached to that? I mean, is that what's required, and do you think that they have that in this case?
Yeah, it's a great question, because there's a lot of confusion out there. For example, Lindsey Graham was out inveighing over the weekend about how outrageous it was that Trump was being charged with espionage. And the thing is, he's not being charged with espionage. This is a series of crimes that are under a general heading of espionage that came into federal law in the 1917 Espionage Act. But in the federal code, if you turn to Title 18, which is the federal code, you won't see the word espionage. What I think the statute is called is something like transmitting national defense information. And it's got, Dana, a series of about, I want to say 6, 7 crimes with some subcrimes in them. And it goes from the very most severe at the very top, which is traditional espionage, the idea that you're like a mole, you purloin national defense information, and then you give it to an adversary country intending to harm the United States. So that's the very most severe. But all the way down to at the bottom, you have negligent mishandling of the information by people who are trusted to have it. And even though in the criminal law you don't usually prosecute people for negligence, this is a different situation, because public officials in the federal government who have security clearances are trained in how to handle national security information, and they make a pact in order to get access to it that they will follow the rules for handling it. So they are prosecuted if they exhibit gross negligence in the mishandling of it. So you have very severe crimes at the top, not so severe at the bottom, like anything that you would call espionage. Trump is kind of charged with something in the middle. He's charged with willfully retaining classified information under circumstances where he was no longer authorized to have it, and he refused to return it to the government upon demand. So that doesn't require any intent to harm the country at all. And the theory behind those crimes is just that some of this high-level stuff, like, for example, if he's got documents that talk about the military vulnerabilities of the United States, some of it is so dangerous to the country if it falls into the wrong hands that they're treated as pretty serious felonies, even though, whenever you get these officials who get charged, the minute the first thing they say is there's no evidence that he tried to harm the country. Well, yes, there's no evidence of a lot of things, but that's not what you charge with,
Yeah, they had some in this indictment. They discussed him showing some of this information, I think, to a reporter. There was one, and we're talking with our friend Andy McCarthy, a best-selling author. There was one incident too where they mentioned he was showing off something related to Iran. And when I was deep diving into some of the details of these charges, now there from what I understand, there's like a whole other bunch of statutes that relate to anything nuclear, anything that's related to national defense, which that surely would be one. And I guess that's the other bundle under which they're charging him.
Yeah, well, this is one of the things, Dana, I don't know if we've talked about this before, but Trump, ever since the Mar-a-Lago search, one of the things that Trump has said publicly again and again and again is that he declassified all of these documents, right? And I have never been impressed with that argument. I mean, I understand rhetorically and politically why he does it, but it is not a defense for the very reasons you just articulated with respect to the kinds of information we're talking about. The Espionage Act does not mention classified information. It says national defense information. So even if he declassified stuff, which there's no evidence that he actually did, but let's say for argument's sake he did, that's not a defense to possessing national defense information, because whether it's classified or not is only evidence of whether it's national defense information. It doesn't settle the question. So if you have a document that's about the national defense, then that's national defense information, whether he declassified it or not. And then with respect to the obstruction counts, they didn't want to get into the morass of whether Trump had declassified or not. So in the grand jury subpoena, they didn't ask for any classified documents in your possession. They asked for any documents with physical classification markings on the document. Mm-hmm. So whether he declassified it or not, he was still required to surrender it under the subpoena. Yeah. So I think, he's talked a lot about declassification, but when you're in this thicket of, as you say, nuclear code information, military information, it's really just not a defense.
Yeah. Oh goodness. It does look like kind of like a mess. We're talking with our friend Andy McCarthy. One of the other things, and this is one of the big questions I wanted to ask you, I keep hearing about the Clinton sock drawer as the defense, and this was related to a case that Judicial Watch had brought some years ago with information that had apparently been squirreled away in Clinton's sock drawer at the time. And the reason that I understand, and that apparently doesn't apply as some sort of precedent to be able to be used by defense in this case, from what I understand, because it was a circuit court ruling or circuit ruling. Why is that?
No, it's a district court ruling.
Okay.
The problem with it is it doesn't help Trump. What you were hearing is their spin on what the case said. But here's what it involves. When Clinton was president, he made an arrangement with this historian to try to cobble together how do I say this with respect to Clinton? Well, I'll just say it. An oral history of the Clinton presidency. So they made a bunch of these tapes during the 8 years, and some of them Clinton kept in his sock drawer. But the problem that Trump has with that is, first of all, the tapes were not classified. They were like an aide memoir for Clinton, almost serving the same purpose as a diary, which in the Presidential Records Act, that's the kind of stuff that can be personal property.
Right.
So they're not classified. They're presidential personal property. And the other thing is, Clinton decided that they were personal property while he was president. So with Trump, what you're dealing with is, number one, you're talking about agency reports from the intelligence agencies. Those are not presidential records, far from being, personal records. They're not even presidential records. They're records of agency activity. I don't even think they come under the Presidential Records Act.
That's interesting.
They're classified, and there's no evidence that he did anything to designate them as personal property while he was president, which is natural, because if a president tried to designate as personal property a bunch of CIA reporting about the vulnerabilities of the country, that would be a problem.
Yeah.
So that's obviously why he didn't do it. But once he's not president anymore, he doesn't have the power to designate it as personal property.
Yeah.
So it really doesn't help him.
Yeah, I have two last questions for you. We're talking with Andy McCarthy. You can read him at National Review. You can watch him on Fox. You can read his latest Ball of Collusion, fantastic book as well. So the comparisons to, we just talked about the Clintons, but also the Bidens. Everyone's asking, and I'm one of them. It seems like a long time coming that there are no charges, especially in some of the investigation that dates back to 2018 with Biden and the questionable financial transactions, et cetera. I always maintain that yes, there's probably a disparity there, but in treatment, and that it does cause people to question the strength of the law if it looks like it's being unequally applied. But that doesn't mean that if they prove their case, that wrong wasn't done here. What do you say to people? How do you explain it to people when they say, well, you have the Bidens that clearly there's some kind of criminal activity going on. I guess the investigation is ongoing, but it does seem like everything was very expedited in this case with the former president and these charges, which makes it seem politically motivated. How do we reconcile that?
I'm with you. I think this is a huge problem. So the Hillary Clinton precedent, I think that argument takes you only so far. Because the travesty with Hillary Clinton is not that Trump is being charged, it's that she wasn't charged.
Yeah.
And if we say that, the Hillary Clinton precedent is an ironclad, immutable rule, first of all, it's obviously not, because they charged Trump, even though he basically did the same thing. But, the logic of taking that position is that we could never again prosecute high-level officials who, play games with national security information, which can't be right. But the only way the Biden people are going to be credible on this is if you demonstrate that there's one standard of justice and that Biden is getting the same treatment Trump is. And so far, that's not even close to being the case. So to my mind, if we're going to have an actual functioning justice system, which is essential to having a flourishing democratic society, it's got to be a situation where you not only have one system of justice, but people have to believe you have one system of justice. Right. And if they don't, like, for example, I wrote a piece for the New York Post over the weekend saying, now that we have this indictment and they itemized all of the classified information that Trump had, let's get an itemized list of all the classified information Biden had. Let's see it.
That makes sense.
And you mentioned the Biden corruption investigation. Where is that? It's 5 years. Nothing has happened. And even worse, there was no basis to have a special counsel in the Trump case.
Yeah.
There's no reason that the Biden Justice Department couldn't have done that case, as they were doing for a year and a half.
Exactly.
So that was just a political appointment. Where's the special counsel on the Biden Justice Department investigating the Bidens? And why isn't every journalist in America screaming about that? Well, I'm ranting because we know why they're not screaming about it, but it's just outrageous.
It is outrageous. The last quick question for you. Miami, apparently being in southern Florida, that's going to help him in this case, as opposed to if this was happening, if this trial was going to take place in like D.C.
Yeah, I think DC is the worst place on the planet for him to bring the case. And I must say, there's a lot of Democrats now who are complaining about this. The judge who caught this case in Miami is Judge Aileen Cannon, who we learned about a few months ago, who was a Trump appointee. And they're all upset that she may be, more favorable to him than what he would have gotten in Washington. But I got to say, they set up shop in Washington in a case where everything happened in Florida. And it was only reluctantly at the very end that they realized if we want to bring the case we have to bring it in Florida because there's not venue on a lot of the stuff in Washington. But for them to have forum shopped the way they did and gotten a Washington judge to say that Trump had no attorney-client privilege, which may end up, that lawyer's testimony may be the most damaging testimony in the case.
Something else. Unfortunately,
now they're going to complain?
Yeah, we have to get moving. Andy McCarthy, I'm always so grateful for your expertise. And as always, you do such a great job breaking it down. Ball of collusion, the plot to rig an election and destroy presidency. If you haven't gotten it, you should. Andy McCarthy, follow him on Twitter as well. Andy, thank you so much. We so appreciate it, my friend.
Thank you, Dana.
Of course.